this workshop. Well, the aim of my presentation is to provide an overview, a very basic approach to the role of the Spanish judiciary in the pandemic. There are multiple questions to address: the capability of the courts for reviewing exceptional measures, the correct or the appropriate level of scrutiny, the relationship between courts and the other constitutional bodies, role of the courts and relationship with experts, the social confidence for citizens as well, to rely on courts for controlling exceptional measures. So multiple questions, and I am only going to setting the scene a little bit and to address some of the questions, but in a superficial way in that way. The structure of my presentation is quite simple. I don't have the PowerPoints. I decided finally not to use PowerPoint, but it's very simple. I will present exceptional law in Spain during the pandemic, the 4 constitutional exceptional moments, and then I will analyze the role of the judiciary in these 4 constitutional moments, and then I will give you some quick conclusions. So first, exceptional law in Spain during the pandemic. First, a preliminary remark. As you already know, in accordance with the Spanish Constitution, 3 situations may be declared in times of crisis: the state of alarm, the state of emergency, and the state of siege. And during the pandemic, only the state of alarm has been declared. As you already know as well, the state of alarm should be declared by royal decree of the government. So the royal decree is the basic norm, the basic exceptional law in the state of alarm, and the measures last for 15 days and then can be extended by authorization of the Congress of Deputies. During the pandemic has been 4 different constitutional moments, so we cannot speak about one exceptional law and one state of alarm for during all the pandemic. 4 constitutional moments, 4 different moments. The first moment, it is the first state of alarm that was declared during the March 2020 and June 2020. This state of alarm was characterized for being a centralized, the measures, the restrictive measures of fundamental rights in this state of alarm were imposed directly by the royal decree, so by the government, and there were no discretion for the autonomous communities during this first state of alarm. And the measures were quite restrictive of fundamental rights. These measures, in this first moment, in this first constitutional moment, affected the freedom of movement, the domicile lockdown, affected also freedom of enterprise. The business activities were suspended that were not essential, these business activities. Freedom of religion as well, the limitation of public acts and ceremonies. And in relation to political rights, that especially Aida is going to speak afterwards, this first royal decree and this first state of alarm was quite silent about political rights. There were no reference to the right to demonstration, and only in May the royal decree was amended for introducing, for allowing, in that case explicitly, the autonomous communities elections, because in Galicia and the Basque Country these elections were imminent in that moment. So this is the first constitutional moment. The second constitutional moment, it is the no state of alarm at all. When the state of alarm was over, then it comes a period that is mostly the summer of 2020 and the beginning of autumn of 2020. There was no state of alarm declared in Spain. This moment was characterized for also decentralization, so the autonomous communities were taking the decisions, and under ordinary legislation, there were no state of alarm declared in that way. And the autonomous communities under ordinary legislation took also restrictive measures of fundamental rights, freedom of movement, no domicile lockdowns, no territorial lockdowns, but yes, limiting public meetings, for instance, and also measures restricting freedom of enterprise, limiting the capacity of bars, restaurants, and shops in that way. So, no state of alarm in this second constitutional movement, but restrictive measures of fundamental rights adopted by the autonomous communities mostly. The third moment, the third exceptional moment during the pandemic was the declaration of the second state of alarm that was very limited in time and also territorially speaking. This second state of alarm was declared only for 9 municipalities of the Autonomous Community of Madrid in October of 2020. And so it is not very relevant in that way. No, but this is the third, the second state of alarm. And finally, we have the currently state of alarm, that is the fourth moment of exceptional law during the pandemic. The current state of alarm was declared in October and is going to last, if there is no any other extension, until this May of 2021. This fourth moment of exceptional law is characterized by decentralization, so it's different from the first state of alarm. And I'm meaning with decentralization that the measures that are provided by the state of alarm, by the Royal Decree of the State of Alarm, should be activated by the autonomous communities, most of them. So there are a lot of discretion in accordance with the epidemiological situation for the activation of the measures provided in the state of alarm. With only one exception, that is the night curfew. As you know, this limitation of freedom of movement during certain hours, that this is a national measure imposed in all the territory. But even in this case, there is some maneuvers, some discretion from the autonomous communities to extend this night curfew that is provided in the Royal Decree during 11 o'clock at night and 6 a.m., but the autonomous communities can extend until 7 a.m. in the morning or advance night curfew until the 10 o'clock at night. So quite discretion of the autonomous communities for deciding in this for constitutional moment. And they can adopt very severe, also strict measures restricting fundamental rights, such for instance, the lockdown of all the territory of the autonomous community, or even county or municipal lockdowns. They cannot adopt domicile lockdowns, but yes, this kind of territorial lockdown. So quite important. Very interesting in this fourth constitutional moment is that the Royal Decree does not provide the possibility in the Royal Decree itself of limiting freedom of enterprise. So any restrictions in relation of freedom of enterprise that they are taking the autonomous communities are based on ordinary legislation and not in the Royal Decree. Also, a fresh addition in this for constitutional moment is that there is a quick reference to the right to demonstration. There is a new criterion for limiting in times of pandemic the right to demonstration. That is the criteria that the demonstration does not respect the personal distance for avoiding the contagious, in that way, but only this thing, very small, so reference to the right to demonstration. And there is also a specific, like the first state of alarm, a specific reference to the autonomous communities election, that they are possible to do these elections. Okay, these are the four constitutional moments, so quite diverse, and they are different, these four constitutional moments. What is the role of the judiciary in these constitutional moments? Well, a preliminary remark as well here. In the state of alarm that was declared only once in Spain before the pandemic, the Spanish Constitutional Court declared that the royal decrees and the extensions of the Congress of Deputies of the measures established in the royal decree are these norms are legislation. Then they have the rank of legislation, so the monopoly for controlling these kind of norms belongs to the Constitutional Court, not the ordinary judiciary. This was a previous settled case law from 2010-2011, the first state of alarm that was declared and the only one before the pandemic in Spain. So what is the role of the judiciary? You can see in the first constitutional moment, the first state of alarm, I said to you that it was quite centralized. So the measures were directly taken by the royal decree. So it should have been decisive, the intervention of the Spanish Constitutional Court. And we expect that. The problem is that I think that you know that there is an ongoing constitutional review. A constitutional action was filed by one political party, Vox, and the decision is still pending against this first royal decree declaring the first state of alarm, this first constitutional moment. There were attempts by individual citizens to go to the Supreme Court for challenging some of the measures of this royal decree, especially freedom of movement, the domicile lockdown, but repeatedly the Supreme Court has declined its jurisdiction and always is saying that this is a question for the Spanish Constitutional Court and not for the ordinary judiciary. So in that way, the Spanish Constitutional Court should be the protagonist, but really we only have one decision during this period, and still it's the only decision of the Spanish Constitutional Court during all the pandemic that is related to the right to demonstration. That is the decision number 40/2020. Only one decision of the Spanish Constitutional Court, and it's quite interesting, this decision. I think that the Spanish Constitutional Court is using a strict proportionality principle and a strict scrutiny, is allowing the prohibition of a demonstration by public authorities, but the argumentation is quite interesting from the point of view and strict scrutiny, but only one decision of the Spanish Constitutional Court in that way, related to fundamental rights, of course, during the pandemic. The second constitutional moment, the second constitutional moment was no state of alarm declared. So ordinary jurisdiction, legislation. So the ordinary judiciary is going to be the protagonist. It's very interesting here because the action of the ordinary judiciary is based in a combination of the sanitary legislation, ordinary legislation, and one article of the law of the contentious administrative jurisdiction, that is Article 10.8, that established the automatic review of the restrictive measures that are taking the public authorities. So during this moment, directly the ordinary judiciary is called for intervening, and then all the measures that the autonomous communities were taking during that moment. Remember that in that moment the autonomous communities are taking the decisions in relation to the restriction of fundamental rights. These decisions were reviewed by the superior courts of each autonomous communities, and we saw clearly activism, and clearly the superior courts applying, I think, also a strict scrutiny. They decided to annul, or sometimes also to validate the decisions of the autonomous communities restricting fundamental rights, especially freedom of movement, the limiting of public meetings, and the limitations of freedom of enterprise. So activism of the ordinary judiciary in this second moment of exceptional law. The third moment in the state of alarm in Madrid is not relevant from the point of view of litigation, and the fourth moment, that is the current state of alarm, well, here in theory we will have, or we are having in that way, a co-protagonism of the Spanish Constitutional Court and the ordinary judiciary. Why? Well, there are some measures directly taken by the royal decree, especially the night curfew, and there is an ongoing constitutional challenge as well before the Spanish Constitutional Court. That also was, this constitutional action was brought to the Spanish Constitutional Court by one political party, Vox, but the decision is still pending. And there are also other pending challenges related to the right to demonstration before the Spanish Constitutional Court, but we don't have these kind of decisions still of the Spanish Constitutional Court. And well, okay, in theory, the Spanish Constitutional Court is going to be relevant, but it's still pending a lot of the decisions of the Spanish Constitutional Court. And the ordinary judiciary is going also to be very relevant, and is relevant as well in three different ways, and very interesting ways that we are saying all these days. First, the boundaries of the night curfew and this limitation of moving during certain hours we have seen some autonomous communities, for instance, Castilla y León, that wanted to advance the night curfew at 8 o'clock, and the ordinary judiciary is reacting and is reviewing this kind of decisions. That is, is going against this kind of decision, against what is established in the royal decree of the third state of alarm. This is one way, a very interesting way of action of ordinary judiciary. The second is the decision of the autonomous communities to activate the measures provided in the royal decree, because this decision belongs to the autonomous communities, and the ordinary judiciary is reviewing this kind of decisions of the autonomous communities. For instance, we had a few days ago a decision of the Supreme Court, precautionary measures of the Supreme Court in relation to the territorial lockdown of the autonomous community of Madrid, for instance. No? So action as well of the ordinary judiciary. And the third way that is also very important to the judiciary these days is all the respective measures that are taking public authorities under ordinary legislation, especially freedom of enterprise, especially the measures that limit freedom of enterprise. Here as well, we are seeing a lot of activism, of judicial activism, with different outcomes, but applying a strict scrutiny as well. In the case of the Superior Court of the Basque Country, for instance, the Superior Court decided to annul the decisions of the public authorities in the Basque Country. But on the other way, the Superior Courts of Catalonia, Asturias, and Valencia decided to validate the decisions of restricting freedom of enterprise of these autonomous communities. So different results, and in that way applying all strict scrutiny in the way that they engage with the scientific debate, with the epidemiological situation, and they are applying a strict proportionality principle with a close eye in the decisions of the public authorities. And there is as well, during this third state of alarm, a very interesting case that Professor Torres Pérez is going to speak to you afterwards. That is the case of the Catalan elections. But I think that as well, this case of the Catalan elections is an example of a strict scrutiny, in this case of the Superior Court of Catalonia, in relation of the decision of the Catalan government to postpone the elections in Catalonia. But Professor Aida Torres Pérez is going to talk about that, and maybe she's going to disagree with me about this is a strict scrutiny or not. But in my case, I think that yes, in my opinion. Okay, so some conclusions, very quick conclusions about all this that I explained to you. First, I think that exceptional law matters for the judicial response. We had 4 different moments, and they diverge, and they are different, and so the judicial response is also different depending on the kind of a normative framework that we have, no, in that way. So this is important, the details, the measures that we take in the royal decree itself of the state of alarm or not, if it is the decisions are taken under ordinary legislation, and so on. No? This matters. This is very important for the attitude of the judiciary. And in relation with the measures that are adopted directly in the royal decree of the state of alarm, so in exceptional law, I think that here is determinant the monopoly of the Spanish Constitutional Court. And this monopoly has advantages and disadvantages. Disadvantages that I think that they are clear, these disadvantages of this monopoly of the Spanish Constitutional Court, is, well, slowness. All the main decisions are still pending, especially the decision for the first state of alarm. So this is maybe a big issue in time of crisis. And the second one is the difficulty of challenge these measures for the private citizen, because at the end, the access to the Spanish Constitutional Court is quite limited. Not only qualified groups can go to the Spanish Constitutional Court, so the exceptional measures are difficult to challenge if they are restricting fundamental rights for citizens, for the city, for their own citizen. And advantage, I think very clear, legal certainty in that way. Only one court is controlling these measures in that way. And also the integrity of the measures itself, of these exceptional measures, because they are protected, only the Constitutional Court is going to control, and the ordinary judiciary is out of this control in that way. And also advantages and disadvantages that we can discuss about this monopoly of the Spanish Constitutional Court. And in relation to the measures that are not in the royal decrees in exceptional law itself, they are based on under ordinary legislation, especially in the no state of alarm moment, and also in the third state of alarm that the courts decided, ordinary courts decided to be quite active. Well, this strict scrutiny, this activism of the ordinary judiciary also has advantages and disadvantages, and we can talk about that. As well, but advantages, clear advantages, the quick justice. They are deciding in team basis in that way, and so this is an advantage. And also an advantage is the easy access of citizens to the ordinary courts, and they can challenge these decisions that are restricting fundamental rights. But a clear disadvantage that we are seeing is the, well, judicial cacophony. In that way, there are multiple courts, all the superior courts are controlling. And so this is difficult to follow the debate. It's difficult for the citizen to understand some decisions that in autonomous community, one superior court is annulling some decisions restricting fundamental rights, and in other autonomous community, the decisions are validated. And this is difficult to understand for the citizens. So, well, but at the end, we can discuss all of these, but the experience of Spain, I think that is showing very clearly that courts are active and they are applying a strict scrutiny. And maybe this might be surprising because we had other experiences in the past, especially in economic crisis, the 2008 economic crisis, in which courts mostly were quite deferential to the power, in the case of Spain. And also, we have experience about national security threats, for instance, that the courts normally in time of crisis, this kind of crisis, are quite differential. I think that is not the case in the pandemic, and the courts are quite active. We will see, especially, the reaction of the Spanish Constitutional Court, because the decisions of the Spanish Constitutional Court are still pending, and maybe this is an issue itself, that it is still pending. But especially the ordinary judiciary is being very active. And that's all. Some thoughts setting the scene about the role of courts in Spain during the pandemic. Thank you very much.
Thank you very much, Joan, for your presentation and for complying with the time. So now Professor Catarina, she's going to talk about scrutinizing violations of fundamental rights in Portugal. So, Catarina.
Thank you so much. I want to greet the chair, Sofia Reca, and the panelists, Joan Solanes, Sofia Pinto Oliveira, Benedita Mac Crorie, and Aida Torres Pérez. And I also want to greet the audience and the University of Pompeu Fabra, and to say that I am so honored to be here today and to share the stage with such renowned panelists. So my subject will be scrutinizing violations of fundamental rights in Portugal and the relevance of courts in times of pandemic. I will share just in a second the PowerPoint presentation. Let me just see, sorry, what happened here. I will try again. Okay, I think now it will work. So, Portugal is jumping back and forward between constitutional emergency and a constitutional normality. In the same way the Portuguese constitution enshrines its amendment rules, it also establishes the substantial and procedural guidelines of the state of constitutional exception. So accordingly, the domestication of the state of exception joins the domestication of amendment rules. And to prevent a unilateral suspension of rights, the Constitution provides a checks and balances mechanism through which the state of emergency is agreed between the three main political institutions. The President declares, the Parliament authorizes, and the government executes the state of emergency. Furthermore, the Constitution puts a cap on the rights that may be suspended, besides imposing a limit a time limit of 15 days, which can be renewed, and the obligation to respect proportionality. During a constitutional emergency, the parliament cannot be dissolved, and constitutional amendments and referenda are prohibited. In a different way from the Spanish or the Brazilian constitutions that identify which rights can be suspended, or the German Grundgesetz that does not make such determination, the Portuguese constitution has adopted a negative design. So the constitution explicitly mentions which rights cannot be suspended, as stated in Article 19.6, the rights to life, personal integrity, personal identity, civil capacity, and citizenship, the non-retroactivity of criminal law, and freedom of religion can never be suspended. Here you have, just for understanding that within a scenario of constitutional emergency, the rights can truly be suspended, whether in a situation of constitutional normalcy, the rights can only be restricted. And the restriction of fundamental rights cannot affect the core content of the rights. But if we are speaking about a situation of suspension of fundamental rights, then it can affect the core content. Sorry, there's a typo there, of the rights. And the duration is limited to 15 days that might be renewable. And there are more procedural limitations. So the pandemic led for the first time since the transition to democracy to a declaration of emergency, followed by others. We had the first lockdown on March 16, and the partial suspension of some fundamental rights, ban on movement, curfews, legal duties of compulsory confinement, special protection, and sheltering at home, shutting down of economic activities, right to strike, assembly, and demonstration were also curtailed. There were, I can say, different types of constitutional emergency. The first one, just 2 weeks after the first confirmed case of COVID-19 in Portugal, and with no reported deaths, the president declared the emergency. To me, this was the only situation in which the declaration of emergency did not substantiate a genuine constitutional obligation. But from a political standpoint, however, Portugal was experiencing disruptive moments of uncertainty and widespread panic, since at the time the pandemic was out of control in Italy and in Spain. So this step forward was probably the best option. But the two renewals were not preventive, they were clearly reactive, and they took place in a more aggravated pandemic context and had further restrictions to fundamental rights. And as the situation in between the end of March and the beginning of November, we had, as I will explain later, no longer a constitutional emergency. We had an administrative emergency that is not at the constitutional level. It is an administrative level. But as the situation worsened in November, Portugal returned to the state of emergency. This emergency can be called an underpinned or an aggravated emergency since January 15, because the cases reached an alarming rate at the beginning of this year, and Portugal was the country with the highest number of infections per million inhabitants. So regarding this idea of administrative emergency, what happened was that there were a lot of criticism regarding the duration of the state of emergency. So as the cases went down, deconfinement started, slow economic reopening, and the relaxation of some of the previous restrictions. So at that time, we were no longer in a constitutional state of emergency. We were in a constitutional normalcy, let's say, but there were also several measures that were implemented. And these measures were administrative measures. There were 3 degrees of restrictiveness of measures taken by the government. The state of alert is the least restrictive state, while the state of contingency is an intermediate state, and the state of calamity is the most limiting of the 3. There could not be a a mandatory duty of confinement, only a civic duty of confinement. And there were also some concerns regarding the Stay Away COVID app that the government wanted to implement at a mandatory level. And so the Stay Away COVID app was implemented as a non-compulsory measure, as the Portuguese Data Protection Commission raised some privacy concerns. There were also a lot of concerns regarding governmental regulation, since this regulation was not subject to presidential promulgation or veto, and was not also subject to parliamentary oversight. So there were concerns in scholarship. Was the administrative state of emergency a de facto constitutional state of emergency, or a soft state of emergency? To some, to extend the state of emergency under a different name, the state of calamity, while imposing mainly the same restrictive measures, would represent a constitutional fraud. So as I was telling you, since November of the last year, Portugal ranked on the top number of infections. We had a new lockdown since January. There was a problem that Benedita and Sofia will address later regarding voting during the pandemic because of the presidential elections on January 24. And regarding COVID-19 jurisprudence, there were some decisions from ordinary courts that validated limitations on cross-border circulation and restrictions to freedom of assembly. In the current adverse situation, the courts play a significant role in scrutinizing COVID-19 legislation, but the jurisprudence is scarce. And I was quite surprised to hear that in Spain, also there is just one decision from the Constitutional Court of Spain. I wonder if this has something to do with the fact that the recurso de amparo constitucional has become more, there was an objectivation instead of a subjectivation, and that is also a question that I have for Professor Joan Solanes, because in Portugal, the main fragility of our constitutional system is the absence of a constitutional complaint mechanism similar to the Spanish recurso de amparo constitucional. The Portuguese constitutional review system is hybrid, as it shares characteristics with the monist Kelsian model and traits of the diffuse model of constitutional review. So in comparison with Italian, German, and Spanish systems of judicial review, the Portuguese system has some unique traits though. In addition to the Constitutional Court, it confers judicial review powers on ordinary courts as well. So if an ordinary judge finds that a regulation applicable to a case is unconstitutional, the judge does not suspend the process and questions the Constitutional Court. Portuguese ordinary justices can dismiss the applicable regulation in that specific judicial process, since they are under a duty not to apply unconstitutional legislation. We had this ruling. It was the only ruling of our Constitutional Court regarding COVID-19. So just to clarify, Portugal is a partial and homogeneous regional unitary state. The archipelagos of Azores and Madeira enjoy limited legislative, executive, and international powers. And after the expiry of the constitutional state of emergency, a Portuguese citizen traveled to the archipelago of Azores and was compulsorily confined following a measure approved by the regional government of Azores for a period of 14 days at its own expense. It should also be stressed that the measures implemented to address the COVID-19 pandemic were stricter in Azores and Madeira than in continental Portugal. This was due to the impairment of the regional health services. So disagree with such confinement, the citizen lodged a writ of habeas corpus against his perceived arbitrary detention. The court of Ponta Delgada, Azores, ruled that the order of compulsory confinement violated freedom of movement and was organically unconstitutional. The restriction, in fact, since the confinement order took place in the aftermath, so it was after the state of emergency, the restriction of this fundamental right could only have been legislated by the Portuguese Parliament or the government with prior authorization from the Parliament. So it could not have been legislated by the regional authorities. Furthermore, the court held that imposing a confinement on a citizen that had not tested positive for COVID-19 disrespected the principle of proportionality. So, but although this decision had only an inter partes effect, the president of the government of Azores immediately announced new measures for containing the spread of COVID-19. And later on, this case was brought to the Portuguese Constitutional Court, becoming its first COVID-19 related decision, and the court ruled unanimously that the regional norms which imposed the mandatory confinement were organically unconstitutional. Right now, we have a lot of pending cases at the courts, both at the ordinary courts and at our constitutional court. And I believe that COVID-19 jurisprudence will become much more dense in the next, I would say, 3 or 4 semesters. What are the main dangers of constitutional emergency? The main dangers that could arise from muscular executives and diminished parliaments are well documented in academia. The government might be tempted to extend its emergency powers beyond the emergency itself. So we have empirical studies that reveal that extended constitutional emergencies increase the risk of democratic erosion and autocratization by decree. States of emergency should be associated with a higher risk of autocratization, and using data from 60 democracies, these 2 scholars found that democracies are 75% more likely to erode under a state of emergency. So what could be done to prevent this situation? I think that at a more fundamental level, a pandemic legislation must be approved. We don't have a specific pandemic legislation, and the current emergency legislation is clearly obsolete for dealing with this pandemic. Nevertheless, a pandemic legislation alone will not prevent states of constitutional emergency, because some measures are so severe that they can only be addressed by constitutional emergency. And this goes back to that difference between suspending and restricting fundamental rights. Fundamental rights can only be suspended in a scenario of constitutional emergency. So how, to conclude, how can the protection of fundamental rights be combined with the strict requirements of controlling the COVID-19 pandemic? Perhaps the answer will lie in this delicate balance of ensuring public health without falling into the extreme of fascist or hysterical hygienic state. This is an interesting expression by Michel Heinig. And above all, we should not give into the naivety of envisioning the administrative and the constitutional exceptions as merely transitory and magically vanishing with the resumption of constitutional normality. I want to thank all of you for your attention, and I'm looking forward to the debate. Thank you so much.
Discussing these questions with you. So in this intervention, me and Sofia, we want to address the effect of the pandemic in voting rights. The COVID-19 has provoked a pressure on electoral democracy worldwide, and many elections have been postponed while others have been held with adaptation. So we will concentrate in the Portuguese situation, and particularly in the experience of presidential elections, which took place on January the 24th. So I will start with an overview of the timeline of the progression of the COVID-19 emergency in Portugal and the legal framework in which the related measures were taken in order to make clear the circumstances in which the presidential elections took place. I think there is going to be some overlap with Catarina's intervention, so I am sorry for that. Maybe we should have talked before in order to avoid that, but I will do this I will discuss this framework anyway. So Sofia will then share with us the Portuguese experience of the presidential elections and the different positions that have been held concerning the constitutionality of a postponement. So the first cases diagnosed with COVID-19 in Portugal were reported on March the 2nd, while the first death was recorded on March 16, 2020. But we now know that the disease was already in the country during the months of February. So half of the 277 persons that entered infected in Portugal during February and March haven't originated big transmission chains. But the other half had a great impact. So although the UK was the country where the biggest number of introductions came from, 34%, the cases that arrived from Italy had a larger repercussion in the transmission of the virus. So one single entrance from the Lombardia region around the 21st of February was in the origin of an outbreak in Ovar, a Portuguese city, and that chain of transmission extended to 44 other municipalities. So it was only on March the 10th, that air connections with Italy were suspended, and a week later the borders with Spain were closed. On the 2nd March, there were 2 cases, a week later it was 30, and at the end of the month there were 7,443. So the effect of the silent circulation of the virus was visible. So following this situation, Portugal has adopted several measures in order to contain the transmission of the virus and contain the expansion of the disease. So in Portugal, if we want to understand the multiple instruments that have been adopted to the same effect, we must distinguish 3 levels. And here I'm following a Portuguese scholar, Miguel Nogueira de Brito. So at the first level, we have the declarations of the state of emergency issued by the President of the Republic, first between March and May, and then since November to the present date, as well as the corresponding government's decrees that develop such declarations and adopt the corresponding executive measures. So after hearing the government and obtaining the Parliament's authorization, the President of the Republic may declare a state of emergency, which allows ordering the partial suspension of citizens' rights, freedoms, and guarantees based on the occurrence or threat of a public disaster. So a state of emergency can only be declared if a public disaster occurs or is threatened. The state of emergencies framework is laid down in Article 19, 134D, 138, 161, 1 and 197, 1D of the Constitution, and also in Law 4486 of 30 September 1986. So Article 19 of the Constitution, which plays here the main role, establishes that entities that exercise sovereignty may not jointly or separately suspend the exercise of the rights, freedoms, and guarantees, save in the case of a state of siege or a state of emergency declared in the form provided for in the Constitution. Number 2 states that a state of siege or a state of emergency may only be declared in part or all of Portuguese territory in cases of actual or imminent aggression by foreign forces, a serious threat to or disturbance of democratic constitutional order, or public disaster. And finally, number 3 states that a state of emergency is declared when the preconditions referred to in the previous paragraph are less serious and may only cause the suspension of some rights, freedoms, and guarantees that are capable of being suspended. So the state of emergency applies to less strict situations. The declaration of a state of emergency grants public authorities with reinforced powers to take the necessary and adequate measures. Obviously, as a rule, the declaration of a state of emergency, also as Catarina already said, must abide by the principle of proportionality and be limited, in particular regarding its scope and duration, and the resources used to what is strictly necessary in view of the specific circumstances. Also, the state of emergency cannot affect rights of superior constitutional dignity identified in the law and in the Constitution. So Article 19 of the Constitution establishes that the declaration of a state of emergency may in no event affect the rights to life, to personal integrity, to personal identity, to civil capacity and citizenship, to the non-retroactivity of criminal laws, the defendant's rights of defense, and to freedom of conscience and religion. The law 4486 of 30 September 1986 adds that the declaration must abide by the principle of equality and non-discrimination and some basic criminal procedure guarantees against illegal arrests and detention and access to courts. Moreover, it may not impose prior censorship of the media or prevent meetings of the statutory bodies of political parties, trade unions, and professional associations. As for its content, the declaration must specify which rights, freedoms, and guarantees are suspended. A state of emergency may be declared regarding all of or parts of the national territory and must only be declared regarding such area or territory where the measures are deemed required to ensure or restore normality. Among others, measures can be adopted to restrict circulation or impose forced quarantine in certain areas. A state of emergency shall only last for as long as strictly required to protect the rights and interests envisaged and to restore normality. Maximum duration is 15 days without prejudice to any renewal for one or more identical periods if the cause which determine it should subsist. So this is the first level of measures that have been adopted in order to contain and to face the pandemic. So at the second level, we have the multiple declarations of the situations of calamity that Catarina also spoke about, some applying in all the Portuguese country and some applying only in part of it, issued by the government in conformity with the Civil Protection Act. So the state of calamity can only be declared when, in light of the occurrence or risk of a serious accident or catastrophe as defined by law and its foreseeable intensity, it is deemed necessary to adopt derogatory measures to prevent, react, or restore normal living conditions in the areas affected by its effects. That following Article 9, number 3 of the legal framework of civil protection. The declaration of the situation of calamity may provide for the civil mobilization of people for specific periods of time, the setting of limitations or conditions to the mobility of people, other living beings or vehicles for their own and the operation's safety, the setting of sanitary and safety enclosures, the streamlining of use of public transportation, communications and water and energy supply services, as well as the use of basic goods. Finally, we have a third level, and we have a legislative act approved by the government and then confirmed by Parliament in terms that give cause to some doubts from a constitutional point of view, the Law Decree number 10A 2020 from March 13, which has been amended over 20 times up to this moment, and it was previous to the first declaration of the emergency state. So this legal framework has intensified the powers of the government, placing Parliament in a secondary position. In Portugal, under normal conditions, government has already legislative competence. Nevertheless, this power has limits. One of them concerns precisely the matters related to rights, freedoms, and guarantees. That is a subject reserved by the Constitution to the Parliament, and the government can legislate only if authorized by a law of legislative authorization enacted by Parliament. But it is a fact that the government played a particularly important role in times of exceptionality. not only has the government executed the decree of the president that declares the state of emergency, but also the insufficiencies revealed by the state of emergency were tackled by administrative legal instruments, states of alert and contingency, and the special administrative state of exception, consisting of the state of calamity. All provisions that strengthen the central role of the government. In addition, although not used in this situation, in the event of public health crisis, the Portuguese law on public health monitoring attributes to the Ministry of Health a competence to enact executive rules, as well as any exceptional measures involving the restriction, suspension, or closure of economic activities, the separation from healthy people, means of transportation or merchandises, in order to deal with the dissemination of the infection or contamination. This follows also base 34 of the Basic Health Law. So secondly, there is also the danger of confusion or juxtaposition between suspension and restriction regimes, as we have already spoken, ruling the same emergency situation. As we have seen since the beginning of the pandemic crisis back in March 2020, Portugal has experienced a cycle in which states of emergency, conceived according to the suspension model, alternate with the less hard situations of contingency, alert, and calamity, and which should comply with the more demanding requirements of the restriction model. When were these different measures then adopted? So first, on March 18, 2020, the state of emergency was declared in Portugal through the decree of the President of the Republic number 14A 2020. The decree imposed extraordinary urgent measures in the form of restrictions over domestic and international movements and the application of social distancing rules. These measures were based on the lockdown of people at home, social distancing, and adopting protective antiseptic policies such as the use of masks. The state of emergency has been renewed twice until 2nd May, having been terminated thereafter. From then on, the state of calamity became effective and was extended 5 times until July. Later on, the situation of contingency in the Lisbon metropolitan area and the situation of alert in all national territory was enacted through Council of Ministers resolution. Later on, the Council of Ministers resolution number 92/8/2020 of 31 October enacted again the situation of calamity in all national mainland territory until 19 November 2020. Due to the increase of infections following the Parliament's authorization, the Presidential Decree number 51/U 2020 of 6 November declared a state of emergency in all national territory for 15 days from 9 November until 23 November, and that state of emergency was successively renewed until 31 March 2021. So January was a particularly difficult month. The successive days with more than 10,000 daily new infections, more than 1,000 per million inhabitants, and the increasing number of hospitalized and ECU patients were, in addition to the number of deaths, the facts that led to the conclusion that this second or third wave, I'm not sure what we should call it, affected Portugal dramatically. So therefore, on January the 13th, the Prime Minister announced that the new confinement was decided from the 15th January on. Businesses that were closed in the first lockdown would once again close, this including hairdressers, gyms, restaurants only being able to offer takeaway options. Supermarkets and pharmacies remained open with restrictions on the number of people able to enter. The Prime Minister made it clear that, on the whole, the rules for the lockdown would be the same as during March and April, with the exception of schools. But afterwards, it was also decided that schools would close, what happened on the 22nd January, measure that extended until the 15th March. So now we are progressively deconfining and hoping that the numbers will allow us to return to some normality. Sofia.
Thank you, Benedita. Electoral procedures belong to the democratic tests imposed by the pandemic over our constitutional systems. Following what Catarina and Benedita said, the Portuguese system has different levels of reaction to situations of emergency and alternates between a suspension model applied when the constitutional state of emergency is declared by the President of the Republic and a restriction model when the severity of the situation does not justify the suspension of rights. So this is the model. What does it mean? It's a different question. When the presidential election took place, we were in the first level with high pressure over the health system and a significant number of deaths. And Article 19 of the Constitution was in force. As already said, political rights are not included in the short list of rights that cannot be suspended. The legislative act that regulates emergency adds a limitation that Benedita has already identified, because according to this law, gatherings of political parties, labor unions, or professional organizations cannot be forbidden or subjected to previous authorization. This provision was a source of problems during the past year, but it's not our subject today. Regarding presidential elections, voter turnout in presidential elections is in general particularly high. In Portugal, in general, voter turnout has been rising for 20 years, but this rise is particularly visible in presidential elections, where from 1996 and 2016, voter turnout dropped by 1 million votes. We are 10 million as a population. Having the president right to a second mandate, in the second election, the turnout is particularly high because the incumbent candidates in Portugal always won the second election. The perception that the election is already decided disencourages the vote. The day for the presidential elections is decided by the president in office. According to the Constitution, Article 125, the President of the Republic shall be elected during the 60 days prior to the end of office, or during the 60 days after the office becomes vacant. The election is decided according to a majority system, meaning that the party or candidate winning more than 20% of the vote wins. If no candidate secures a majority in the first round of elections, another round is required to be realized 21 days after the first round. In November 2020, the spreading of the pandemic was already out of control, and there was a discussion in Portugal if the election should and could be postponed or not. Different concerns were presented. The sufficiency of health and safety measures in polling stations to avoid the increase of COVID-19 cases, and the fairness of an election where the incumbent candidate was a protagonist of daily political life, especially given the state of emergency, and other candidates faced with campaign limitations, obliged to remote campaigning. Constitutional lawyers express different opinions. We are referring, and this is an important remark in my opinion, we are referring here to opinions as they were transmitted through newspaper and other media, because most of the scholars did not express their positions in writing. I think this warning is important because, as we all know, what we read in the press does not always correspond to the opinions expressed, but correspond to the interpretation of the journalists of these opinions. Some defended that the election could be postponed. The emergency decree, this means the president in office with authorization of the parliament could suspend voting rights due to the emergency situation. This was a position defended by Jorge Bacelar Gouveia, Paulo Otero, and Raquel Brígida de Castro, who wrote on this subject. Others defended that the situation itself did not justify the postponement of the election. Jorge Reis Novais was in this group and defended just an earthquake or a dramatic event as such could justify the postponement. Others, like Jorge Miranda, defended that a revision of the Constitution providing the postponement of the presidential election due to the state of emergency was necessary in order to postpone, but not possible due to Article 289 of the Constitution. Article 289 provides that no act involving the revision of the Constitution may be undertaken during a state of siege or a state of emergency, as Catarina has already referred. Being the president in office, a former professor of constitutional law, his view was coincident to this last position. The election was not postponed. The end of the story is well known. The president maintained the election on January 24th and won the election in the first round with 60%. Some adaptations were introduced to allow those who were confined or staying in hospitals to vote. But even with these arrangements, some could not vote because they were in prophylactic isolation, for example. The turnout increased, but not in dramatic terms. There were less 500,000 voters than in 2016. Several questions remain unanswered. First, could the election be postponed? And if so, what kind of scrutiny would be in place? To define the date of the presidential election is a political act of the president, not subjected to judicial control. Courts cannot appreciate such a decision which interferes with the voting rights of the citizens and the core of democracy. According to the current constitutional system, solely the parliament could interfere, not authorizing the state of emergency. Second, could the election be maintained even applying strict measures interfering with the electoral campaigning? What decision would serve better the democracy? It's difficult to answer. In our opinion, and using the three levels presented by Benedita and designed by Miguel Nogueira de Brito, we think that health and safety guidelines like hygienic measures in polling stations can be applied in all levels. Measures interfering with electoral campaigning, like limiting the number of participants in political events, can also be imposed on all levels, but under a strict scrutiny of proportionality. And national courts, until now, always avoided reviewing the proportionality of COVID measures. And this is a problem. As Catarina stressed, the case that was decided by the Portuguese constitutional law, the Court of First Instance considered that the measures of confinement in Azores did not comply with the principle of proportionality, but the Portuguese Constitutional Court just considered the question of competence of the regional governments and clearly avoided the substantial control of proportionality. Once these measures interfere with political rights, they have to be decided by the Parliament, in our opinion, and can be challenged before the courts, especially the Constitutional Court. The third level of measures, the postponement of general elections, of presidential election, in our opinion, is possible, but is only possible during the state of emergency, which means when the first level applies. Maybe the solution could be some difference in local and regional elections. As a conclusion, just a short remark. The pandemic puts the constitutional system under a stress test. elections are sensitive moments of this test. It's not easy to find a balance between different interests at stake. Nevertheless, as far as the presidential election is concerned, in our opinion, the system is flexible enough to deal with emergency situations. Thank you very much for your attention.
Thank you very much, Benedita and Sofia. So now Aida Torres is talking about democracy in the pandemic, the tension between public health and voting rights. Aida, go ahead.
Great, yeah, thank you so much. And first of all, I would like to thank Benedita for the kind collaboration in co-organizing this workshop, and also to all the speakers for accepting to participate. And also I'd like to thank Sofia and Marga for their invaluable help. And now just let me share my screen. Can you see it? Yeah. Just a second. Yeah. Okay, so according to the International Institute for Democracy and Electoral Assistance in the world, about 73 countries decided to postpone elections due to COVID at the national or subnational level, whereas about 86 decided to have their elections as they were planned, with special measures, such as the case of Portugal, Croatia, or Romania in Europe. So the question I would like to address here is, to what extent may elections be postponed for the sake of public health in the context of a pandemic, or in other words, to what extent the right to vote can be limited in order to protect public health. And first, I'll analyze the tension between the fundamental rights at stake to understand the framework for analysis better. Then I'll address the legislative framework in Spain regarding the possibility to postpone elections in emergency situations, and focus on the case of the 3 regional elections that were scheduled and took place over the pandemic, in the Basque Country, Galicia, and Catalonia, and compare these situations. And then I'll focus on 2 particularly controversial issues that have to do with the role of judges and the conditions for voting in the pandemic, and then I'll conclude. Well, then, as I just mentioned, in the context of a pandemic, there is a tension between public health and the right to vote. There is a risk of infection when elections are celebrated. So the question would be, well, to what extent may the right to vote be limited? But we need to take into account that the right to vote actually is on both sides of the debate here. Right? On the one hand, the normal functioning of a democratic system requires periodic elections for the citizens to be able to elect their representatives as an expression of the political pluralism, and this is an essential feature of a democratic system. But at the same time, we know that the right to vote is not just about casting a vote one day, but a fair and open campaign needs to be ensured. So the fact that celebrating elections under the pandemic might actually also undermine the right to vote from a collective and also from a more individual perspective. From a more collective perspective, as I was saying, celebrating elections in the pandemic might actually undermine an open and fair electoral campaign, also the organization and the development of the electoral process. And from a more individual perspective, it might hinder the right to vote when people might fear to get infected, particularly vulnerable groups. So in this discussion, I think that we need to take into consideration the integrity of the right to vote from these 2 perspectives. Then if we move to the case of Spain, and the question is, may elections be postponed in an emergency situation, the general legislation actually doesn't provide for, in general, for the possibility to suspend or postpone elections, although it refers to the possibility specifically of suspending acts of voting or public scrutiny in case of force majeure, which needs to be interpreted. Regarding the exceptional legislation, already Joan referred to that. The Constitution provides for 3 different states of emergency: alarm, emergency, and siege, depending on the seriousness of the situation, and then the powers that are granted to government, and also depending on the rights that might be suspended. But actually, in the state of alarm, no fundamental rights might be suspended, although, as we were discussing before, there might be restrictions as a consequence, for instance, of the restrictions on mobility. In any event, if we focus on the decrees that declared the first and then the second state of alarm, at first nothing was said regarding elections, but then the decree of the first state of alarm was amended in May to incorporate this clause that you can see, saying that the state of alarm will not prevent neither the development nor the realization of the electoral activities necessary for the celebration of elections for regional parliaments. And actually, this clause was incorporated in light of the elections that were going to take place in the Basque Country and Galicia after they had already been postponed, right? And they were going to take place in July. This same provision was reproduced in the decree that declared the second state of alarm. So there is no explicit legal basis for the postponement of elections, but we might ask ourselves to what extent force majeure can justify the postponement. And I think that we cannot exclude that possibility. If we are in face of an unforeseeable situation, and as a consequence of that, it becomes impossible to hold the elections. In any event, I would just like to make reference here to a report by the Venice Commission that is of relevance in this context. And as you know, according to Article 15 of the European Convention, it is possible to derogate human rights in time of war or other emergency threatening the life of the nation. And in this report, the Venice Commission interprets that this refers to circumstances that relate to war or other ongoing armed conflicts, high-level terrorist attacks, but also natural disasters or epidemic, right? So according to the report, there is no general principle to avoid elections during the state of emergency and postpone them until the situation is back to normal. And also, but that doesn't mean it cannot happen, right? So it is said that the postponement should be provided by law, although that's not the only possibility. Also, it is acknowledged that the factual situation may require the postponement of elections, and that in any case, the suspension must meet a proportionality test. And then it's interesting how in the report there is a list of issues that, according to the Venice Commission, need to be taken into consideration. And for instance, they focus on the larger scope of abuse, right? That those in power might fear a loss of the loss of power if elections are held, and that might be a reason for them to postpone the election. So that needs to be that there needs to be a system to be able to control, right, the decisions of the political authorities in that regard. And then there are a set of issues to be taken into account, such as, well, how the factual situations impact upon campaign possibilities, campaign costs, the security of the members of the polling stations. They need to take into account different voting modalities, the turnout. So these are all issues that I'm going to refer later on when I analyze the case of Spain. So if we focus then on the regional elections in Spain, as I said, there were 3 regional elections scheduled over this time. And actually the 3 of them were postponed by the respective governments, right? So just let me give you a bit of context, particularly for our Portuguese colleagues. In the case of the Basque Country and Galicia, the elections were called for on 10th February 2020, so when the virus was still a Chinese issue. And actually, we couldn't imagine that a month later the situation was going to be the one that we had here in Spain and other countries also in Europe. So what happened is that after the declaration of the state of alarm on 14th March, 3 days later, the elections were postponed, and they were finally held on the 12th of July. In the case of Catalonia, the elections were called for on the 21st of December 2020, although we already knew since October that we were going to have elections, because those elections were the result of the disqualification of the president of the government, and since there was no alternative candidate, automatically elections had to be called for. So we already knew that those elections were going to take place. So they were scheduled on the 14th of February, but then by governmental decree, they were postponed to the 30th of May. What happened here is that the High Court of Catalonia annulled this decree, and finally the elections were held at the date when they were scheduled originally. Okay, so in none of these situations there was an explicit legal basis to postpone the elections. So the question is, to what extent the postponement would be justified on grounds of force majeure. And I think here that the differences between the situations in the Basque Country and Galicia and Catalonia justify the postponement in the case of the Basque Country and Galicia, but not in the case of Catalonia. And just I'll briefly refer to those differences. First of all, in the case of the Basque Country and Galicia, the decision to call for elections was discretional. I mean, that the regional presidents have that power to dissolve the parliament and call for earlier elections. Whereas it was compulsory for the reasons that I just stated in the case of Catalonia. However, I don't think that this difference would justify necessarily the postponement in the first case, because the fact that the presidents have the power to call for elections doesn't necessarily mean that they have the power to postpone them. In any event, in the case of the Basque Country and Galicia, there was a legal vacuum regarding the possibility to postpone the elections, whereas in the case of Catalonia, as I just mentioned, the decree of the state of alarm positively acknowledged the possibility to hold elections during the state of alarm. Also, in the case of the Basque Country and Galicia, we can say that the situation was unforeseeable. As I just mentioned, maybe we were quite naive at that time, but we couldn't imagine what was going to happen a month later. Whereas in the case of Catalonia, the elections were called for after the second state of alarm had already been declared. Also, in the case of the Basque Country and Galicia, the legal restrictions were much more severe. We had a strict lockdown, so people couldn't leave their houses except for the realization of essential activities. Whereas in the case of Catalonia, there were and there are some restrictions to mobility at night within territorial limits, but non-essential activities are allowed. And finally, in the case of the Basque Country and Galicia, there were very poor conditions to ensure the protection of health at the time. The lack of knowledge about the virus, the shortage of basic means of protection, face masks, protective suits, tests, even for doctors. Whereas in the case of Catalonia, we have much better conditions in order to ensure the protection of health. So I think that all these differences justify the postponement in one case, whereas I don't think it was justified in the second one. So if we analyze then the role of judges in the pandemic in this area very briefly, here the postponement in the case of the Basque Country and Galicia was not challenged, But later on, in the case of the Basque Country, there was a challenge against the celebration of elections in July, arguing that the celebration of elections could breach the right to health, physical integrity, and also the development of a fair and open campaign. However, this complaint was dismissed by lack of legitimate interest and legal foundation. And then we have the case of the High Court of Catalonia, as I just mentioned. The decree, the governmental decree postponing the elections was challenged, and here the High Court first adopted interim measures to suspend that decree, and finally the High Court annulled that decree postponing the elections. And basically the arguments were that there was no legal basis, that the postponement could not be justified either in terms of force majeure, since the situation was not unforeseeable and it was not legally or materially impossible to hold the elections. And the court also analyzed or developed a proportionality analysis to decide whether the restriction on the right to vote could be justified in light of the development of the correct development of the electoral campaign, the free exercise of the right to vote, and the protection of health. And the court concluded here that actually the restriction on the right to vote was too intense. Actually, remember that the elections had been postponed to May of 2021. So that the court argued that enough measures could be taken in order to address those concerns. So finally, the elections, as I said, took place at the time when they had been scheduled. So here we have, in this context, obviously a tension between deference and activism. Some analysts criticized the decision of the High Court of Catalonia because of their activism, whereas others justified or defended the judgment, I would say the majority of them. But in any event, it's a fair question, the one about the role of judges in protecting fundamental rights in the context of the pandemic, and it's actually a challenging one. So very briefly, since we already discussed about that, I would say that in the context of a pandemic, we might demand a bit more deference, more judicial deference, to the extent that we can say judges lack the expertise or lack the more immediate knowledge of the situation, and they cannot replace the political judgment of the authorities. But at the same time, in my opinion, when the functioning of the democratic system is at stake, they have an important role to play in preventing abuses of power. So it might be very tempting for those in government to try to extend their mandates or self-perpetuate themselves. So judges, I think, have this role to play in preserving the integrity of the right to vote. And finally, since I'm afraid the time is running, I'd like to address some of the challenges also of voting during the pandemic. So in the context of the pandemic, special measures need to be adopted to ensure both public health and the exercise of the right to vote with full guarantees. The problem is that in Spain there was no specific legislation providing for special measures, neither at the national or the regional level. It was for the governments at the regional level to take those measures. As a consequence of that, the electoral administration had a very intense role in responding to the questions, complaints regarding the measures that were taken or not taken at the time. So I'll briefly refer to four issues that I think are particularly problematic. First, postal voting. Obviously, postal voting is a suitable measure in the time of a pandemic. And actually, postal voting increased in the 3 regional elections. And the decree of the state of alarm included a clause saying that the government would make sure that the public postal services would collaborate in the celebration of the regional elections. So some measures were taken to make it more flexible. For instance, voters could cast their votes at the moment when the mailman delivered the required documents, instead of having to go later on to the postal office. And the Central Electoral Board clarified that that was an open possibility for any citizen, regardless of age or health condition. But at the same time, for instance, there was a request for the possibility to enable the postal service workers to go physically to the residences for the elderly in order to help them with the application for postal voting. And actually here the electoral board rejected that possibility, and the reasons were the lack of legal provision, that the petition was made too close to the date of the elections, those were the Catalan elections, and also the risk of manipulation or influence on the vote of the old people. I think that might have been too restrictive because, well, first it is assumed that just because they are old, they can be manipulated, and that other measures could have been implemented, such as the presence of a person of their confidence. Then the question about the people infected with COVID. Actually, in the case of the Basque Country and Galicia, the respective governments decided to ban people infected with COVID from voting in those elections. And that affected to about 200 people in the Basque Country and 250 in Galicia. In the case of Catalonia, they were allowed to vote, but they were required to do it by the end of the election day, between 7 and 8, when the members of the polling stations wore the protective suits. In that case, actually, there was a petition before the Central Electoral Board to actually deprive the possibility of going personally to vote for those people infected with COVID. In this case, the Electoral Board said that that was beyond its competences, that the right to vote was a fundamental right that could not be taken away by the electoral administration, and that enough measures had already been implemented to preserve the health of the people involved. And actually, I think that the decision by the governments of the Basque Country and Galicia to deprive the right to vote to people infected with COVID was an undue restriction of an unjustified restriction of the right to vote, and therefore unconstitutional. Actually, in a press conference, the political authorities of the Basque Country, for instance, argued that, well, people who were hospitalized because of a heart attack or a hip fracture could not go to vote either. But we are not talking here about the people who were hospitalized because of COVID, but just about the people who were at their homes, and still they were not allowed to vote personally. Then regarding the members of the polling stations, there was a concern in all the elections about the need to secure their safety. And there were general measures implemented, face masks, social distancing, and so on. Also, the Ministry of Health, vulnerable groups that could be excluded from the obligation to be part of a polling station, those with a heart condition, chronic lung disease, diabetes, cancer, pregnant women older than 60 years old. The number actually of people who presented allegations to exclude themselves increased, but in the end there were no significant problems in constituting these polling stations. There was again a question about before the electoral administration about the possibility to call for volunteers. And actually the Central Electoral Board rejected that possibility because of the lack of legal provision. Here, the Electoral Board argued that according to the legislation, the substitutes of another polling station could be called for, or even voters who were present at the moment. So don't go to vote too early, or you might end up in a polling station. But in any event, volunteers were excluded. And I think that that was quite reasonable in order to keep the fairness and the appearance of fairness of the process. And finally, regarding the turnout, obviously in a pandemic, we might expect a lower turnout, and that's what happened. In Galicia, it dropped about 5 points, in the Basque Country 9, and in Catalonia 25 points, which was quite dramatic. The preservation of the level of participation and the legitimacy of the results might be a reason to postpone the elections in the pandemic. Actually, the fear to get infected might discourage people from going to vote. But I think that if enough measures are implemented to ensure safe conditions, that's not a sufficient reason to postpone the elections. Actually, the reasons why people go to vote or not are very diverse. And in the case of Catalonia particularly, I think that the reasons had to do, in addition to the pandemic, with other matters, such as the fact that the independentist divide was not as prominent as it had been in previous elections, because in Catalonia participation had increased since 2012, and it reached almost 80% in 2017, which was also unusual. So that's why afterwards we had this dramatic drop in terms of turnout. So finally, and just to conclude now, I think that holding regular elections is an essential feature of a democratic system, and that needs to be preserved also in the context of a pandemic, and that only exceptionally, for reasons of force majeure, may the elections be postponed when the integrity of the right to vote is compromised, and that judges have an important role to play there in supervising the action here of the political authorities. And that although the risk of infection cannot be totally eliminated, as in any other activity, sufficient measures need to be implemented. And unfortunately, I believe that in the case of Spain, the measures were taken hastily with by the governmental authorities, instead of providing for a suitable legislative framework. So thank you so much.